But nevertheless, that can sort of work. You know, try to show perhaps, so say, be creative. Think about that this is, you know, what's the first law of ecology? Everything is linked to everything else. Show how it, you know, you come up with a imaginative food chain or food web or something like that. Show how that the fate of this little indicator species or something, the snail, has ramifications for a broader, you know, health of the Cumberland Plain woodland, or, you know, for Sydney or something. You know, trying to think of how to make it, you know, sexy basically is what you wanted to do. So there's always a way of doing it, just keep brainstorming. I quickly showed there, we don't use enough aids in court. You know, photos. These days you can do, there's no reason why you can't have data protection in court. I had a really good, it was a civil case brought by the government. We had some digital sort of aerial photography and overlaid and put it up, you know, blew it up right up into big sort of, you know, things on the wall of the courtroom, and it was so powerful. And in fact, that was even done in cross-examination. And so when the witness sort of said, no, nothing happened, let me just zoom in on that. Oh, is that you down there? Oh, whoops, yeah. And so, you know, Google, that's a wonderful thing. So, you know, think about how you can make it much more than just you know, a dull sort of legal point, you know, but good facts.
It's actually a bit of a running joke at the EDO every time we approach with an environmental problem and trying to come up with a cause of action. We think, where's the charismatic megafauna? And come up one, we'll have quite a running joke about that. But we have had some, I definitely agree with Justice Preston's comments on that, and I think you can make everything sexy somehow. You just got to have get a bit creative about it. But we have had some challenges at the EDO over our time in this regard. One example is an attempt to protect, it was a native vegetation removal case at BCAT relating to some old dead bull oak trees in West Wimmera region, which were being used as habitat by the red-tailed black cockatoo. And at the time there was only about 1,000 of that species, that subspecies left in the area. And I think Birds Australia were our client for that matter. It was before my time at the EDO, but Brendan, our CEO, tells a good story about the site visit that the BCAT member did down at West Wimmera to inspect these trees and to try and catch sight of these red-tailed black cockatoos, which they didn't, of course. And the result of that that site visit was pretty much, you know, there's no birds, we couldn't see them, and this, what are we trying to protect here? These big dead old trees. You know, it was like it's one of the challenges I think of environmental law is translating the significance of conservation of wildlife, things like that.
I think I was just saying, you know, opening and things, you know, remember that we can use rhetoric to very effectively, you know. I can remember one person who was doing a case and who about a bandicoot, etc., and sort of, you know, went to a sort of, you know, classic Australian poem and sort of stood up and opened, you know, before sort of saying anything, just read part of this about the bandicoot, and then sort of, you know, said, this case will decide the fate of, you know, the long-footed bandicoot or something. Well, it was effectively a bit of rhetoric, you know, and a bit of theatre about it. You know, in common law, for example, we forget how they do. I mean, I don't know if you've heard of Clive Evatt, but, you know, it's the whole lot of Clive Evans, but Clive Evatt's seen as complete rogue. He's dead, sorry, no defamation now. But he was very effective. I mean, in one case he had of a person who'd lost their leg in an accident. So, needless to say, notwithstanding it was the middle of the winter, he was instructed to come in wearing shorts. And at that time it was still a jury, so that sort of the stump of the leg was sort of protruding from these very short shorts. But then he got a mannequin's, this is Clive Evatt, he got a mannequin's leg, wrapped it up in brown newspaper, and put it on the end of the bar table in sight of the jury. The jury never listened to the other side. All they could do was they kept looking at the plaintiff with his stump coming through his stubbies and this leg sitting on there, and they were convinced that that was the leg. Well, of course, he won with, bells on. And it didn't matter what the defendant said, it actually, made not the slightest difference. So, we've got to remember, I'm not suggesting wrapping a dead tree or a cockatoo up, but, be creative, think of it. Yes, at the back.
Justice Preston, I was wondering if we might be able to come back to the question which was apparently asked of Michael Kirby, which unfortunately I missed, ironically, due to his rescue and injured Lorikeet, about animal rights as opposed to animal duties, as the other speaker mentioned might be more suitable. I've wondered, I work with a group called Lawyers for Animals, and we're coming up against this issue just repeatedly, constantly, ever since we commenced operation, of animals being treated as property. And because my undergraduate studies were in history, and I sort of majored in American history and looked at the slavery movement or the abolitionist movement, I can see these very direct parallels now between the animal rights movement and the anti-slavery movement. And I'm wondering whether you think that rather than duties to all animals, as there was the Code Noir, which protected the welfare of slaves but really undermined effectively the rights of slaves, whether we might move toward more of a guardianship model for animals, and whether the guardianship that we have for legally incompetent humans might in time be a way to look toward protecting animal rights and nature in general.
Peter's the best way to talk about it, but look, we should, without necessarily going to the full point where we say that all animals, all plants have equal rights with humans, which is going to be a big jump. Nevertheless, we can think of it in at the margins. Your example of sort of the guardianship one is an interesting one. If you've read Christopher Stone's essay and later, book, Should Trees Have Standing, where he talks about that concept where you could point, a guardian for nature, and they could come forth and talk on behalf of the river, etc. It's not so silly when you read the article, and it could be done. There's an article I published talking about restorative justice, where I sort of said where you have these restorative justice conferences, there's no reason why the environment couldn't be represented by Environment Victoria or some other body, and speaking on behalf of them. And I give examples where that's been done in different countries, including New Zealand. So, we can think of ways, and when one does that, of course, one does give. And if you think of rights as being like a bundle, there are certain aspects that you can give. And of course, in the duties one that Peter's talking about, if you remember Hofeld, this often, the correlative. So if you give a duty, even if you don't give a sort of a positive right that can be asserted, the fact that somebody can go to court to prevent a breach of the duty is in a sense giving some degree of right, you see, without giving them the full right. So I think you can do some things, and you can work incrementally to improve the empowerment of the nature.
No, I don't have too much to add. I think, as Stone points out in his essay, this idea of guardianship, we have people that speak on behalf of corporations, we have people that speak on behalf of mentally impaired children. I think guardianship's a fine idea, a fine concept. The point I'm raising is how politically possible and what language you use in terms of getting the message across. I think rights and duties could both embody some concept of guardianship.